All right, so I'm going to start just with a quick introduction about the law, and then I'm going to let Stephanie take over on how it actually works on the ground. So if you're looking, you've heard about this law, but you can't seem to find it. It may not have made it into your newer versions of Chapter 7B, but you can find it online at ncledge.net. I believe that's the right resource. But it is found under 7B-909.1, point 2, and point 3. I will tell you that point 1 and point 3 are super short. Point 2 is really long, and that's the meat of the entire program. So one of the things that you need to know about this is a very short summary. That thank you to Stephanie for summarizing the 3 provisions, basically, which is that before a parent executes a voluntary relinquishment of their child. So we're talking about a couple of possibilities, right? Either a petition for TPR has been filed, or we're trying to avoid having one filed in the first place. And the parent has expressed an interest in signing a specific relinquishment to the person that currently is looking to adopt their child, whether it's a relative or a foster parent or anyone else. In that potential adoptive placement is also an agreement with having what you and I have normally called open adoptions. We've never had open adoptions in North Carolina. This is our version of it. It does not apply to private TPRs. It only applies to cases in which DSS is involved. So before a parent, a parent would express an interest in doing this program. It's voluntary. They tell their attorney, the attorney tells DSS, DSS double checks with the adoptive parent that they're willing to do it. They sign an agreement and they send it to mediation. So I think that's pretty much like kind of how we get there. We'll go through the forms later, but Stephanie, why don't you tell us a little bit more about the program?
Sure. I'm happy to do this and really anxious to get to the part where you ask me questions and I give you some case examples. But first of all, also the uniform rules for this program are on the NC Court's website, and there'll be a link to it on the last slide. And that walks you through each stage of this. And when I first reach out to parties who I get on this referral form, 214, I get a referral form from usually the deputy clerk. Then I try my best to reach out to those parties. The hardest thing is I don't have contact information. All I have on that form is parent attorney email. So I reach out to them, and I've been slowly spreading the word to DSS that if they can give me the contact information for the prospective adoptive parents, then I can reach out to them. It's a voluntary program, and on the form that they get, number 6 on the referral form, says that they will contact me, and it gives them my contact information, but maybe 1 in 100 does that. So I spend some time trying to reach them. When I am able to reach them, then I provide like an orientation by phone right now. My hope is to create more orientation material that's on our website for people to look at in advance. But I talk with people, and some of the slides I'm going to be sharing with you now are things that I talk with them about, that this is entirely voluntary, that anybody at any point can decide they don't want to continue with mediation. And I don't report to the court who decided to move forward and who decided not to. Sometimes it's obvious to the court for various reasons, but I don't divulge that. Just like if they have a draft of an agreement and decide not to sign it, I'm not sharing that draft with anyone other than the parties who participated in mediation. So it's not going to be sent to the court or to DSS. That's up to them to decide who to send it to. If they tell me in mediation they want me to send it to their parent attorney, then I'll certainly do that. But I just want to reassure them right from the beginning that they're not going to be punished for changing their mind or for not signing the agreement. In mediation, it's only the referred parent and prospective adoptive parents. However, if they decide together that they all agree on including somebody else, someone else can attend. It's usually a support person, and that person isn't participating the same way that the parties are in mediation. I can allow them to go into a breakout room to talk privately, because all of these are held remotely. So they can go into a breakout room and talk, or if they're in the same room, they can mute themselves and meet. But that additional person is really meant to be a support person for them. They'll have plenty of time to talk before and afterwards with attorneys or anyone else if they'd like to. And then once they have an agreement, I send it to them to review, to get notarized. We'll talk about all that later. And then finally, the judge reviews it and decides whether or not that they're going to sign that. And sometimes that's a surprise to the parties. So I always say it right in the beginning. Okay, can you go to the next slide?
Yep.
All right, and then I let them know these are the 3 areas where they can agree on. They don't have to agree on all 3 things. They always focus on visitation right off the bat, unless a parent is incarcerated. In those cases, we're usually talking about an update, what kind of updates they're going to receive, how they're going to receive it, and how the adoptive parents are going to be kept informed of different email addresses that this person might have. So yeah, it's a much more streamlined agreement than we do in custody mediation. And we are helping parents and parties look at all number of things, just how this is going to really, really work on a day-by-day basis. So I let them know that our job as mediators, like I don't research the file, I don't know what did or didn't happen, that's not my job. Our job as mediators is to really help this conversation. That's what's important for us. Everybody else is doing their jobs, so we can just focus on this. And part of that is to really help them be specific, since this is going to be a court order. And there are, when it's a kinship placement, I've found that a lot of our job is translating to the parties what this agreement is and why they might need it, because they want a lot of flexibility. They already have had a lifetime of flexibility with each other. And oftentimes in kinship placements, they have a lot of contact with each other and don't want this document to interfere with that. So what I've tried to explain to them is this is a safety net against the worst case scenario happening. No one's going to come out there and say, hey, this is more than 2 visits, except for them if they need to do that. So there's a lot of helping them understand what the agreement is and how it's really meant to be a safety net against the worst case scenarios happening for both sides. And then we start looking at how it's going to function on a daily basis and getting them to be as specific. When it's not a kinship placement, oftentimes the prospective adoptive parents come with very clear ideas and boundaries, and yeah, so that's been helpful. I would say the biggest challenge and the thing that I hope that they are receiving from their attorneys, and I really urge them to please talk with their attorney before mediation, is this mental switch from moving towards reunification and the visitation plan that was in place for reunification and now post-adoption contact. So a lot of times the parents will tell me, well, this is going to be the same. And, I'm again asking them to talk to their attorney about what's realistic, and it has to be agreed upon by all people. And I'm just seeing a question pop up. Yes, Rule 17 attorneys, what I've been told by our counsel here is because the law is not clear on it, I am supposed to ask each referring judge what they would prefer. And so sometimes they don't get back to me, the judge doesn't, but in most cases they want me to reach out to the Rule 17. And then that person is definitely included. It would be my preference, for sure.
Stephanie, I don't know if you saw the other question, which was, if they've already come up with an agreement, then, how do they do that? What do they do with that?
Yeah, sometimes they want to send it to me, and I tell them, just like I say in custody mediation, please hold on to that and bring it yourself and use it. But if everybody already agrees on something, then it'll be really quick. And I will just put it in the form that then they'll be bringing to court. But oftentimes they haven't necessarily communicated on all those details. And a lot of times it's because the parent is still hoping that it's going to be similar to the reunification plan. So I haven't had one yet where it's some kinship, they're pretty close, but there's usually some logistical issues that haven't really been sorted out. and also like a plan B. If this doesn't happen, you know, then what? So those things. So, but I'm happy that they've done a lot of thinking and working on it, and they're welcome to bring it and use it. And we'll be taking notes. Typically, a mediation right now is a custody mediator who I'm training. So not every custody mediator is going to have time. So the legislation was passed, but funding wasn't included. So I am trying to train a handful of mediators who either have time or a great deal of interest in this, and then kind of try to spread the work out. We just have no idea. We had no idea how many referrals we've gotten, we would get, and it's only growing. So I have to hurry up and get people ready. I'll talk a little bit later about the huge difference in this and custody mediation. So it's usually a mediator. Right now, it's somebody who's watching and observing me or another mediator, and then a scribe. And so that way, at the end of the mediation, we can pull up some of our notes on the screen and go over it with people right then and there. If we have a ton of referrals, I don't know that we're going to be able to do that. So far, since I guess November, December, we've had over 30 referrals, and each of those referrals takes an enormous amount of time just trying to get contact information. The mediation itself is the easiest part, and that's usually 2 to 3 hours. It just depends. And then sending out the documents. We know how many have reached agreements. I can keep aggregate data, but we don't know what happens after it leaves. Send it to the parties, and then it's up to them to have it notarized and signed and submit it to court. And our job is over, but we are still finding that we kind of need to have our foot in the door a little bit to help people navigate that piece. Okay. Is there any pressing question before I go on?
There was just a question about, like, if parties want to modify that, but I can talk about that when we get to the law. Yeah.
Yeah. Well, that's coming. That's coming. And I let them know that in the orientation about modification.
Yeah.
Okay. Can you go to the next one? Yeah. So just helping people understand what direct and indirect contact is. So we've had many referrals of incarcerated parents, but it's been, unless I have a direct number for the person in the prison who will be able to set up the WebEx, I can't really move forward. So in one case, a parent attorney moved heaven and earth to get me that contact. And so we are going to be mediating. I've mediated in 2 other situations where a parent is detained. And again, I had a direct contact. Some places just won't do it. Some places, they never call me back. So anyway, with those, we're often talking about indirect contact updates, how that's going to happen, and so on. All right, the next slide. Yeah, so this is modifications. As a way to protect the adoptive parents, so at least that's my understanding, the law says that the modifications can only limit, restrict, condition, decrease, or terminate the agreement. So you can't expand it, in other words. Yeah, and one of the ways that I talk about the agreement is it's the minimum. They can always do stuff by mutual agreement. And oftentimes, especially if it's kinship, they already have experience with that. So they can always add, by mutual agreement, add more time in. And we talk about that. So there's 2 conversations really happening in mediation. One is what's going to go into the formal document. And the other one is if things work. I mean, they're bringing that up. And then I help them see, well, that's one of those maybe, if this works, and I help them understand what do the adoptive parents need to see from the parent in order to have some of that flexibility that they're talking about. And it's usually consistency. And a lot of times the adoptive parents want the parent to be the one to initiate the visit. Like, say they're having 4 visits a year. In the agreement, then they make it clear that the parent is going to be the one to call on the first week of the month and arrange that visit, and then confirm 24 hours in advance, so that the adoptive parents aren't getting children ready and going to some place where someone's not going to show up. So they've thought about those kinds of things oftentimes and have all of that built into the agreement. But typically that's part of it, is that the onus for arranging this or initiating the calls or whatever it is will. Oh, and because once the agreement is signed, it becomes a civil child custody agreement. It's still in the protected area of Odyssey. But when they file a motion to modify, it is going to go to custody mediation. And not just the people I've trained. It will go to any custody mediator. I'm training them to be able to identify that this is a modification of a post-adoption contact agreement, which means that those parties need to bring that to mediation because the mediator will not have access to it. And then it can only be, decreased, restricted, etc. Okay, next one.
I think we're up at the forms.
Yeah, and I'll turn it over to you. All I will say is that, I get the referral form 214. I don't need 213. And because I really only need one form, I don't need, if there's multiple children, I don't need both. So people can, kind of squeeze things in that top line. And also clerks or whoever's filling these out, they're finding ways to sometimes give instructions to me in some of the empty boxes, like, the addresses are kept confidential, there's domestic violence, something like that can be put there. And even some people are putting in contact information for me. So that, or in an email, that's always hugely appreciated. And is there anything, Anik, that I need to address before we move to this?
I think it's mostly going to be about the forms and concerns. We're going to
Oh.
come back to these. I did want to put this up there, which is the link to the program. And what I will do is I will put it up on the listservs as well. And if people could share, but it is on the AOC website. So you could see that. So I'm going to attempt to change. One of the questions that that people had was, what about like who's talking to the adoptive parents about this?
I mean, prior to mediation?
Prior to, who's telling them about this program? And yeah.
If they've been referred, then I'm calling all parties and doing an orientation. But I'm guessing that the social workers are talking with them about it in advance.
I agree with you. I think that, just as the social workers, by the way, can you guys see the forms? Oof, wrong one. Okay.
I don't know that you've shared your screen yet.
See, this is part of my technical difficulties.
See that share button?
Yeah. Yep. No, it's because my computer is not wanting to have two PowerPoints open at the same time. So it's giving me a hard time. Okay. Can you see the form now? LCJ 213?
Yes.
Okay. So this is the first form. Okay. And so here's how I kind of envision it happening. By the way, I've had to learn more about this process in the last 6 months, as has Stephanie, than any of us ever thought we would, right? So the way I envision it is that the parent is having a conversation, the parent attorney is having a conversation with their client, having a discussion as to whether or not they know the potential adoptive, if they've got already some relationship, they might not have any relationship really, but if they're open to a discussion, at least a mediation about whether or not they would relinquish their parental rights to this specific individual. And you have to remember that this is only for specific relinquishments. I know that some of the DSSs are asking for general relinquishments, and it's not, right? So yes, Valerie, this is what it is. This is basically the attorney. I think how it would work is that the parent attorney would approach DSS and says, my client is willing to sign a specific relinquishment to this potential adoptive family. Would you accept a specific relinquishment if they are able to reach an agreement? So this is the first form that starts this path, right? It's AOC J213. you'll see that there is information. Unfortunately, we only put the AOC form only has addresses. And what I'm hearing Stephanie say is that it would be super helpful if you include maybe a phone number or an email address, some other way that she can contact them more quickly than waiting to send a mail, you know, or even waiting for them to contact her, right? So this is a notice that basically DSS has to sign, that they agree that if the parents can reach an agreement, both the biological parents and the adoptive parents can reach an agreement, that they will accept this specific relinquishment. Sherry, I understand that some of the counties refuse specific relinquishments, but let me tell you, they're going to want this if it's not for every case, right? But if the right case comes along, they will accept it in this one because it avoids them having to go to TPR and a potential appeal and the delays that brings, right? So again, that's a potential. And you'll see that at the bottom of it, there is this thing that says basically that they're agreeing that they will participate. And so I believe that this is also on J213. So there's an acknowledgement that both of the parties have agreed that they will participate voluntarily. You can't force people, right? If they won't do it, they won't do it. That's why I'm saying it's not for everybody. And then we get to this form, and this is the form that Stephanie needs, the AOC 214. So what it does is that, again, this is the form that has a lot more details. It's probably better. I see that it says email of the attorney, for example. I know some of you are terrible about responding to your emails, so Stephanie's probably trying to chase you down to get contact information for your client. If you can put it in this form, then that would be helpful. And I'm trying to think who, at the bottom, it's a referral and notice to mediation, which I believe is signed by the judge. I don't have the full form in front of me, but that's what triggers the process, right? So DSS files the AOC J213 saying, we will accept the specific relinquishment. The parents have said they will, they agree to participate in mediation. The adoptive parents have said they'll agree to do mediation. Your Honor, please order this to go to Stephanie for mediation. And if they come to an agreement, then this is what AOC J215 looks like. It's going to attach the agreement. It's going to be notarized by everyone, and this is going to become a court order. So I heard, I think one of the comments on here was, what happens if they don't have an agreement? Well, if they don't have an agreement, they don't have an agreement, right? You're going to continue to proceed with either the TPR or whatever the other permanent plan is, right? So this is why, though, if you look at it, the statute requires that the relinquishment, the specific relinquishment, be signed and submitted basically with, at the same time, or I'm trying to think what the wording is. Let me look at the statute, sorry. That it needs to be, I'm missing my form. That is to be done at the same time or after the agreement has been reached and becomes a court order. Because what if the judge doesn't like the agreement, right? What if the judge doesn't sign and approve this agreement? Then there's no specific relinquishment, right? And again, even if the judge signed the order and there's no specific relinquishment, this agreement is null and void. One of the conditions precedent for this order to take effect is that the parent has signed a specific relinquishment. So the reason you don't want to have the relinquishment signed beforehand is because there's only 10 days to revoke your relinquishment. As you're hearing from Stephanie, it takes a long time to set these up. And so that 10 days is going to be, it's going to have come and gone. So that's why the specific relinquishment is not signed until afterwards. I think that's all I had on forms. But again, as a reminder, that 7B 909.3 makes very clear that in order to modify, this is going to go actually to Chapter 50, and it's going to start a new action. And that it cannot be used to expand, which is why Stephanie was saying earlier, this is your worst case scenario, right? You can always have more contact if you're in agreement to it, but this is going to be the minimum that you have to do by law without being found in contempt of court, right? So DSS does not have an opportunity to review the agreement. You are not a party to the agreement.
That's right.
Neither does the GAL, right? Because this is an agreement between the biological parent and the adoptive parent. This takes you out of the equation. And that was done on purpose, quite honestly, because otherwise we're imposing our beliefs on what the contact should be. And we're not the ones who have to live with that for the rest of the child's minority, right? It's these two parents, sets of parents that have to live with that. I think also, I'm going to let Stephanie talk about other issues that have come up, but I think it's, one of the issues, I'm going to stop sharing now. One of the issues that comes up is the mediation with both parents together or separately? Does it make a difference if the parents are together or not? So we're going to have to ask the judges, what is it exactly that they want us to do? And again, it's only by going through this process that we're learning these gray areas that weren't foreseen when the statute was drafted, right? And so I encourage DSS and GAL to send us any notifications or contact Gail Corelli for DSS attorneys, contact Reggie for the GAL attorneys. Like, we want to know, what are your concerns about this? And are you talking to your own, they're not your clients, right? Foster parents are not your clients, but your social workers are definitely talking to the foster parents about adoption. So, I'm sorry. The question is, I think, what's happening in the meantime? I think in the meantime, you're just having reviews of permanency planning hearings, I should say, right? Unless what I want to specify is that this is not meant as a way to delay permanency. This is actually a way to expedite permanency, which is why we need to be talking to our clients as parent attorneys early on about whether this is a possibility. Questions? Let me go back, I guess. Stephanie, did you see some questions there that we need to do?
I just wanted to chime in that, not all of these cases are appropriate for mediation. So I saw something about if it was mandatory. So it's not mandatory. It's completely voluntary. And I think people can let the judge be aware of some concerns if they are coming to mediation, so they can review the agreement. I had a lot of concerns before I started doing this, and a lot of them I don't have anymore now that I've been mediating for a while. But not all of these cases, not all cases would be appropriate for mediation. I think the ones that I've found really interesting and inspiring are when those parties are very motivated to work together for this content. The motivation isn't necessarily just to speed up the case. I understand why that's a motivation for a lot of people and a lot of the professionals. And we work really hard now to try to not just have cases sit in limbo. So if I can't reach parties after several weeks, I can let people know, hey, I still don't have a contact information. I can let DSS know. So when I get a referral, I have a whole spreadsheet now, and I try to write immediately what county it's coming from, what contact people are there, professional contact people. And technically, the parties are supposed to reach out to me. So a lot of DSS now that I've worked with are reminding the parents, and the parties to call me. That really helps. And as soon as they do, I start the process. And I think by the time I can reach people, they usually have an appointment within those 3 weeks. And I want them to have, sometimes they need time because they need to talk to their attorney and they need to just really sort out the difference between, they're kind of in whiplash mode from reunification to this. And bypassing mediation, right now the law is not clear on that. So I saw that comment. That could be something in the future, but right now the law doesn't specify how that would happen.
So there's a couple of questions from DSS attorneys about, at the end of the day, it's the DSS director that signs off on whether they accept the specific relinquishment or not, right? So the question is, will that affect the director's decision to accept the specific relinquishment or not? And here's the thing, AOC J213 is signed and says that that the director will accept a specific relinquishment between these two parties, right? And so I'm looking at it. It is actually signed. As attorneys, you're going to have to talk to your director because you're signing on it, or you can have your DSS director also sign AOC J213. And here's the thing that I want you to remember. You're only going to accept doing this process when you know who the adoptive family is and you have trusted them. You've already vetted them that they're going to be the adoptive parent anyway, right? You're not picking John Doe from down the street, right? You have already expressed an interest that these people have that child's best interest at heart. And that's what we're getting to. These children, I'm imagining, although I've heard that we had a baby at least in one mediation, but a lot of these children that are being adopted are older and are aware that they have a parent. So you have to trust that the people who are going to be adopting the child have the child's best interest at heart and know how to protect that child from any, which is why the law also says you can only reduce. If the parent acts like a fool, they're going to lose their privilege, right? They're not going to have the contacts that were agreed. Even if it was 4 times a year, they're not going to go down to 0, right? So this is what we as parent attorneys have to remind our clients that, there's incentive for you to get along with the people who are adopting your child if you want to be able to continue to receive the contact that you've agreed to. Stephanie, can you think of other things? Yeah.
Yeah, and a lot of times we're putting in they're discussing kind of a fallback plan. If the parent doesn't initiate the visit or doesn't confirm the upcoming visit, then the visit won't happen. The next visit will happen. If they don't do it for 4 visits in a row, these visits will just not take place and it'll go to indirect contact. So people are often thinking all of this through in advance and putting in contingency plans in the agreement.
Yeah, so one of the other questions was this Form J213 need to be submitted to the court before accepting a designated relinquishment. And the answer is yes, because AOC J213, all it says is if they can come to an agreement, we will accept a specific relinquishment, right? There's no specific relinquishment until or unless there is an agreement, right? If there's no agreement, there's no specific relinquishment, you're right back at TPR.
Yeah, I see a question about whether the agreements apply to pre-adoption period. They can talk about it, but that's not what we're writing.
Right.
Um,
Question is the foster parent's address required? It's not on the form, but you would need to send it. It is on the form for AOC J214.
Yeah, now I've had some people fill it out with just the name and then write into there the address is withheld.
Okay.
So if it's being withheld or like for a notice to me to not to share. So I typically on their agreement forms send them to the different parties and just take off the other addresses anyway.
Yeah, and I think, but I will say this, right? Unless there's some other form of agreement, I think there needs to be, right? Maybe an email, because maybe it's not, we talked, Stephanie mentioned direct and indirect contact, maybe the agreement, and we'll talk about in a second, like what kinds of agreements have been made. But yeah, let's be clear. Some of these are not that the parent's going to see the kid, right? And one of the other questions is, can one parent agree and not the other? Yeah, absolutely, right? We can have an agreement with mom or dad, and the other parent gets TPR. And guess who's going to get some benefit, right? The one who participated in mediation. So.
And if both parents are living together, I mean, I can't tell if they're married, but then I just ask the judge, are they supposed to be in mediation together? Are supposed to have the same agreement? And that's sometimes why we're withholding. I think that's why the form it says withhold addresses for the other parent, not because of the adoptive parent.
Right.
So adoptive parents often want their address withheld from the.
I get it. I understand that, right? And I think, you know, there is this this confusing time period between when we have an agreement, which again doesn't take effect until there's an adoption, right? So it's not just that there's a specific relinquishment, is that also the adoption has to go through, right? Because in the meantime, DSS are the custodians, and there is no civil action to enforce it because, again, we don't have the adoptive parents as parents before. During that time, you're still just going to be doing post TPR or permanency planning reviews during that time. Other questions? Stephanie, do you want to talk about okay, questions about does DSS have to refer this case to the program? No.
No, once the judge signs 214, the clerk usually sends that to me.
Yeah, but you know, again, you know, if you want to have a policy that none of your adoptions are gonna go through any of this, then that's the call of your director. If you've got a policy that you will not accept specific relinquishments if there is an agreement, or you don't trust that the foster parents will, you know, the adoptive parents will hold the agreement, then one of the things that I would urge you to consider, though, and again, you've heard 30 cases. How many cases do we have facing TPR in North Carolina? It's a very small, it's not for everybody. It's a very small number, but that number will avoid the delays of having a TPR, having hurt feelings over the things that we have to say during TPRs, and hopefully there'll be some kind of a cohesive relationship between the biological parents and the adoptive parents that is to this child's benefit. I think that was the motivation behind this proposal.
Yeah, when I ask adoptive parents, you know, what's their reason for choosing this, every single one has said the same thing, and oftentimes it's very young children as well, that they feel like this is in the child's best mental health for their mental health. And, you know, that some kind of contact, you know, this child is from these other people, has a different culture than theirs, a different race. And so they want to maintain that contact to some degree. And the conversations that we have in mediation, the things that don't go into an agreement, I think are almost as important as anything that does go into an agreement. Oftentimes, so there's these different categories that I'm trying to train mediators to look at in advance. Do the parties know each other? They may have never talked before, especially if someone's incarcerated, and now they're going to be having this conversation. Often, many times, the parent wants to thank the adoptive parents. They want some time. And, you know, they're expressing, as this one parent said, I think it was the first mediation I did. She said, I'm not going to say that I'm not the best person for my child because I am the best person, but you're also the best people for her. I mean, it was so intense. It was so perfect how she just summed all of that up. And it really is what a lot of people are trying to say in the beginning, this kind of walk this balance between surrendering this and also still supporting the process and being involved in the next steps. So there's a lot of grief and gratitude. People are asking questions about medical history. People are asking questions about names, especially, again, if they haven't known each other. Some of the best mediations, though, are when people have had a lot of success together. You know, they know each other. They know what to expect in these next steps. So 100% they're not all appropriate for mediation. And my hope too is that, you know, there are opportunities to have our legislative liaison talk about some changes to the bill or some additions. And I would hope that there's more clarity on the Rule 17 in being included. That would help. And if there's other things, you know, I'm sure you can pass them to me or Anik, and we'll see if there's some ways to tweak certain things, because there's a lot of gray area that we're still trying to figure out.
I'm answering questions as they come up. Mostly it's about like what happens if the adoption doesn't go through. And I'm like, then it's void, right? There's no agreement because the agreement is premised on two things. The agreement is premised on one, the biological parent signing a specific relinquishment that is accepted by DSS, and two, that the adoption goes through. If either one of those two doesn't happen, then the contract is null and void. Stephanie, do you want to give us some examples of things, like what kinds of things that people are talking about and agreeing to?
Sure. I mean, it runs the whole range from an update twice a year to a father who was just about to be incarcerated, to uh, every week a visit, to a kinship placement where it's between a mother and her grandmother. And, like as they were saying, they could already agree to do things on their own, right? After adoption, people can agree to do whatever. But this gives them a safety net of what they can be held accountable for, what the rules are. Again, they can expand those rules on their own, but this is the bottom line if they run into trouble. So yesterday they were talking about the father's past drinking history and what happens if he relapses, and putting in kind of a relapse plan into their agreement. Um, so, so yeah, and when we have kinship, there's a whole different dynamic. I'll say that, in custody mediation, we're dealing with people with high conflict, betrayal, a lot of anger. That's not what we're seeing in this. And I know some is just because there's a very different power dynamic, but there's also just a very different history. And there is a lot of gratitude. People are not just using that, nobody's prompting them to be grateful, but there is a completely different dynamic. And the more tricky thing then for the mediators to help them get specific and understand why specificity is needed. And so if you're talking to somebody before mediation, that'd be a good thing to help them look at, what kind of plans would they want, how specific. I don't know, I'd like to hear some more questions about that. I think I've given you an idea of, sometimes people are having a lot of more communication, depends how, like phone visits. Um, so far, everyone's agreeing that the adoptive parents will be present, will be monitoring these unless they feel it's not necessary. Uh, yeah.
Yeah, and I think that that's going to be our role as parent attorneys, right? Is managing our clients' expectations. I mean, if I have an incarcerated parent that's serving a 30-year sentence, I mean, the best they're probably going to get is like maybe the occasional letter or something, right? Like an update on how the kid is doing, maybe a photo from school or something. So I think one of the beauties and the advantages of having the mediators involved in this process is that they've seen a lot of things from their custody mediation that feeds into this, right? I have not done family law in 25 years. And so, but I remember, like, when I lived in South Carolina, one of the big things we had to talk about in mediation is who does the kid get to evacuate with during a hurricane, right? Like, I wouldn't even have thought about that. But like when you live in the South and on the coast, you got to think about like who gets to evacuate with the kids. So I think also with it, one of the questions that has come up is that there's no GAL or DSS present in the room, but there's also not a parent attorney, right? The parent, I've always said we attorneys tend to be a bull in a china shop when it comes to mediation. We frequently cause trouble when there doesn't need to be. That's why this is a voluntary program, and it is meant to be agreement of what they are happy and can live with, right? And again, it doesn't mean, Stephanie mentioned that there was one parent that had a drinking history, right? So part of the agreement may also be if at some point you relapse and we can tell that you've been drinking, you're not going to get to visit with your kid that day, right? We have the right to cancel that visit. And by the way, if that parent doesn't stop drinking when they are supposed to have visits, then what's going to happen is that the adoptive family is either going to stop, and now the parent has to try to sue to enforce that. But the defense on that is going to be, well, they're always showing up drunk and that's not in this kid's best interest. And so we actually want to terminate the visits. So, I think there's going to be a lot of learning. But that's why we need your feedback also. Like, what are you guys seeing and how can we help change the process? Stephanie, you mentioned that there was an incarcerated parent that is going to hopefully be allowed to participate. By the way, if you're all having issues in getting set up, someone else mentioned that they're having their client read it over so that they can participate in the mediation, which I think is another way to potentially do this. So I don't know about whether there's any hard cap. That's one of the questions on any letter or telephone visitation that they could have with the child, or is it up to the incarcerated parents and adoptive parents that are willing to agree? I think it's both, right? I mean, in the sense that it has to be whatever the agreement is, monthly or whatever. The child is never under an obligation necessarily, right? I think it's an obligation. By the way, Stephanie, did I hear you say that you've had one where the child was part of the mediation?
No,
No, okay, okay. I just
no,
wondered, whether that might come up at some point, right? If we're talking about a 14-year-old, for
right.
example, right? A 14-year-old might want to have a say on whether or not they get to see their parent, even if when they're agreeing to being adopted by someone else. So that's obviously
Done that in permanent mediation, but not in post-adoption yet. I would say the majority right now are pretty young children, but we have had families where there's like children about 10, 11, 12, that age range. And the incarcerated, and there have been a number of referrals with incarcerated parents, but we've only been able to conduct 2. We have another one scheduled. Again, that attorney deserves a medal for getting me the contact information, because it's out of state prison. And a lot of it depends on if the court and the facility have established a relationship, and then there's a designated person I can call to set up WebEx. Somebody was telling me to set it up through JurisLink, but I don't know that that's really the best way, of how private it is. So what we prefer is somebody who's going to, just like they would have a remote hearing in a separate room with WebEx. Some facility, if you can give me the exact name of a person who will do that, then I can set that up.
So that sounds like it's more doable with in-state people than out of
Well,
state.
this attorney did have success with the Kentucky prison. What was I going to say? But so far, all the agreements with an incarcerated parent, well, I guess there's been 2, have not involved visits that the child would visit in the prison. Or even a phone. It was more updates to this person.
And I think that's what I would envision, right? Like I will say this, as a parent attorney, what my clients want to know at the end of the day is that their child is going to be loved just as much by their adoptive parent as they were loved by their parent, right? And so they just want to, they're not, I think sometimes we build up this image of like a monster that's going to come and kidnap the child or try to take the child away, and that's not. They just want to know that their kid is happy and healthy and secure in their forever home, right? And so I'm actually hoping that this might actually increase the number of relinquishments, specific relinquishments. And, in other states, they have open adoptions. They've had open adoptions for a really long period of time. It's just that it's new to us, right? So, yeah. How about any? Yeah.
I mean, there's things that they want to say to each other that a lot of times, especially a parent who's incarcerated or about to be incarcerated, has never had a chance to say, and to ask each other, what is this? Why does this child need this? What does this mean? What can I tell the child about this? The parent wants to know, do you have pets in your house? Because my son loves pets. They want to know these things. This doesn't go in an agreement, but we spend a lot of time just talking about these kinds of things.
I think it's one of the wonderful things about this is that it takes away some of the anxiety that both parties may have about each other, especially as you've mentioned, if they've never had interaction, right? Some foster families are really good about the shared parenting, but in some, it's just either not possible or not done. And so, as you mentioned, this might be, or someone's been incarcerated, right? And so there's not been an opportunity for that interaction.
Right. Yeah. So that's happened quite a bit. They're just getting to know each other. And I've had adoptive parents tell me afterwards that they had no idea it would go so well. They were really kind of prepared for like this brutal negotiation. Do I need to get an attorney? We're going to do a settlement. I was like, no, I'm going to have a conversation. I promise you, I never will let it get out of hand. I will never let that happen. And it doesn't even come close to that. Custody mediation, different story. But so far, there's, like I said, there's a lot of grief and gratitude, and we just make for a lot of that, and then steer them through their options around what they can agree to. And again, getting clarity is the biggest thing. Again, some adoptive parents come with it all laid out.
Yeah. So one of the questions is, due to the length of time that it often times takes for adoption to be finalized, sometimes at least a year. I've actually heard almost 3 years in Wake County. Does this contract remain valid until such time, or does it have to be updated? And, you know, the law doesn't answer that. My guess is that it's valid. Could it be that there's grounds to modify it in the Chapter 50 once the adoption does happen because something has happened in the intervening time? Maybe. But we're still new enough that we haven't gotten to that. I would venture to say that while Stephanie doesn't know, because we don't track this, you know, out of the 30 mediations or so that you've done, how many of them have led to an agreement?
All of them.
All of them. Okay. But I'm guessing that out of those 30, we potentially don't know yet whether the adoption has gone through, correct?
Yeah, I don't even know if it's even been signed by the judge. So
Right.
we know that they've reached an agreement. We sent the draft out. And in some counties, you know, the judge has said to alert the clerk. This is also a gray area. What do I do? Do I tell anybody that an agreement has been reached or not?
Ah,
I'm just not supposed to keep data, but I have to keep
right.
some to keep track of things. So, and then I delete. But so I don't know how many actually made it, because after, you know, the agreement goes right on 215. It's not attached. I put it on 215.
Okay.
Then I send it to the parties. They have to get it notarized. First of all, some of them are going to have a hard time even just printing it out. So I send them to their attorneys if they're parents, and to DSS sometimes will help if they're adoptive parents. They get it printed, notarized, and they bring their separate sheets. Either they just give it to the attorney, some DSSs will bring it to court, or they can stop down at the courthouse and give it to the clerk. And then the judge will review it and I'm assuming sign it.
So this sounds like, yeah, we will need to fill in some of those gaps. And, you know, as a reminder to everyone, we're in short session this year, but we're in long session next year. So this will be our opportunity if we need to tweak the statute in any way, shape, or form. For example, you know, I don't know that I necessarily want to skip the mediation process if everybody's come to an agreement, because it sounds like with a conversation with Stephanie, that sometimes they'll find gaps that they hadn't really thought about, or different, you know, other things that they might always benefit from. But, you know, one of the things that we talked about is what happens if the judge won't approve the agreement, right?
Yeah. Yeah. And, you know, the thing I hear, I mean, I'm trying to make more connections with DSS, which only helps all of this process. Parties will tell me that sometimes they're confused, that they think that what they've already signed the relinquishment form, or that they had to do this. They didn't even know what this was. So that's why I want to have some information on the website so people can, DSS can refer people to look at a video or something on the website. What I would love to see is more staff for this program. You know, we're using staff, we're already busy.
Well, okay, so that will need to add also on the long session, right? A request for more staff for this process. But one of the things is that I believe that we also have GALs on this webinar, and we also have some foster parent associations. And so I think they're trying to put together some information as well about this process. And so I think once we all start coming at it, because again, this is meant to be a cooperative, right? This is not a fight. This is because we've all agreed that this is what's best for this child. So I think once we start coming up with some of the tools, I know, for example, in our office, I've got 2 interns this summer that are going to be putting up these slides and other checklists and resources for both attorneys and parents. So, you know, stay tuned. And maybe we'll need to do one of these post-adoption contact agreements part 3 in another 6 months and see how things have been happening. But I would love to hear at some point, and I know that we're almost at the hour here, but I would love to hear from some of the DSSs or any of the parent attorneys that have been involved. If you've had any interaction with this, how has it felt? Are there concerns or other things that you think that we need to address, or other questions? Does anybody have questions we can help answer?
I see Ms. Davis's question. I don't think we've had a case yet where there's children in separate homes, but I don't see a problem with mediating that if all the parties are involved. And I did have a kinship uh, placement where the mother was talking about another child of hers. I don't know if it's formally at another person's home or informally, but they were talking about who could be present during the visits with the child in question, and that name was mentioned. So we often talk about we almost always talk about who can be present during any visit. And sometimes other family members are mentioned, and then that goes in the agreement. Or it goes in the agreement that only other people that we agree upon in advance will be at the visit.
Okay.
I
So
don't,
again, lots of information, but I think the some of the main issues that I wanted to clarify is obviously Stephanie needs contact information. I think hopefully we've driven that home today. And then the other thing is, again, there's no relinquishment signed until they come to an agreement, right? And then it'll be a specific relinquishment, not a general relinquishment, because that's what's going to make this work. And again, it's not for everybody. But hopefully it'll help reduce the number of TPRs. Hopefully it will help reduce the backlog of cases. And again, at the end of the day, hopefully this will make families in whatever new shape they're in stronger and for the benefit of this job. Any parting words, Stephanie?
just thank you all for your interest and for the help some of you have already given me. And as we muddle through what to do, I really appreciate it. And I'm very hopeful about this program. I think it's a good one.
Me too. So we're going to get some more help for you so we can refer even more cases. And I think as we spread the word about this being available, and again, my preference would be that we refer before we get to the TPR stage or before, definitely not once the TPR is already scheduled. But again, I think the more we can have these discussions, I think the more everybody will benefit from it. So. All right. Thank you all very much. I appreciate your time and we'll see you next time. Bye-bye.